Hey, good morning, good afternoon, good evening, everyone. We are about a minute away, or actually right now, 9 o'clock. So I wanted to welcome you to How to Raise Seed Funding for Your Startup, talking about convertible notes and safes. So a couple housekeeping issues to take care of. This is being recorded, so we will make the link available shortly afterwards, and we'll send it out. So you'll have a chance if you don't attend today, or if you didn't get a chance to listen to the whole presentation, it will be made available. So you'll have a chance to listen to it at your convenience. So looks like there's a few more people joining, so we'll maybe give it a minute or two before we start. It looks like we've got a pretty good list of folks that are attending. So thank you for taking the time to listen in. Hopefully you'll get some good nuggets of information. Happy to follow up with any and all of you afterwards. If you have issues or questions that you wanted to ask, certainly feel free to reach out to me. My contact information will be available at the end. And it looks like we're getting a few more people. So why don't we go ahead and get started? And as others join in, then if there are any questions that we can answer towards the end, happy to do that. I typically try to reserve a good amount of time towards the end of the presentation. So if there are questions or comments, welcome them. If you want to put them in the chat, I'll try to get to them towards the end. If I get a chance throughout the presentation, I'll try to go through them as well. But sometimes it's a little bit easier to go through the material and then circle back around to address any specific issues related to questions or comments that you had. Welcome any comments too. So if I'm talking about a particular topic and you've experienced something or have a comment or something you wanted to share with the group, happy to have you comment on that and share as well. I mean, we try to make this as a informal process, a discussion, if you will, as possible, notwithstanding that it's virtual and I unfortunately can't see everyone. But anyway, so let's go ahead and get started. Really excited to be here today. Really look forward to talking about startup funding, seed funding, convertible notes and safes, and some other things of what to do to prepare for your first seed funding. So I'm going to run through a little bit of an agenda, and we'll then do a little bit of a poll so I can kind of get a sense of the makeup of the audience, how many people are entrepreneurs, founders, executives, investors, just so I get a better sense of how to maybe adjust some of the topics. So one thing that I think would be helpful is to, give me 1 second here. Okay, so just keep in mind, this is all educational. I'm not providing legal advice to any specific set of circumstances. Everyone's individual circumstances are completely different. So something I may talk about generally may or may not apply to your particular circumstances. So consider this educational. If you have specific legal issues you want to address, I'm happy to talk to you offline at a different time. Just reach out to me, let me know, and we can set up a time to chat. But just want to make sure everyone's aware this is all educational and there's no attorney-client privilege in connection with these materials being presented today. Okay, so just a quick little overview of the agenda. I'll do a little background on myself and the firm. We'll talk about some of the sort of the early planning things that you should be aware of. So if you are going to be going out to get seed funding, which is typically your first formal funding or that a company will do to get enough cash in the door to be able to start development and production and to get your business going, then there are some things you should be thinking about. You may have already taken care of these, but if you haven't, or if you maybe haven't done them in a particular way, I'll give you some tips on how to set it up so that you at least have the best presentation when you go to talk to investors, that you've got all of the structural issues that investors are looking at and typically will require have been taken care of. For example, choice of entity, jurisdiction, things like that. So we'll talk about that, and that breaks down into a couple different areas, such as, the kind of documentation that's really important when you first set up your company. What are some of the types of financing options that you have? We'll talk about convertible securities, which come in a couple different flavors, but in particular for this presentation, it'll be talking about convertible notes and safes. So talk also about foundational basics of some basic information that you should be familiar with or should be aware of as you're going through your seed financing. We'll talk about how to close or how to prepare and run through and close your seed financing. And then some of the common pitfalls I see from time to time that have come up over the years, and not having done things properly, or maybe missing something, or maybe not understanding something as well as the founders might have, and as a result ended up stepping on some mines or falling in a few pits that can cause problems and either delays or issues that need to be resolved, in some cases can't be resolved and create a big mess. So we'll talk about some of those common pitfalls, hopefully give you some information to take away that here are some things to avoid. Okay, so let's jump right in. Whoops. Okay, a little bit about my background. So I'm a corporate attorney with Foley and Lardner, been practicing for 20 plus years, primarily focused on emerging growth companies in venture capital. So startups, everything from beginning to end. So from very, very early setup of the company all the way through liquidity. So exit, M&A, the whole life cycle of a startup. I represented clients that have been on the company side, but also on the investor side. So very familiar with what both of those clients are looking at, and sometimes the perspective and the lens through which they're looking at things is different. Obviously, if you're on the company side, you're thinking about things that relate to the company. If you're on the investor side, you're thinking about things that relate to the investment, protecting the investment, and what sort of things investors are looking for in order to invest in a startup. And we'll talk about a little bit of both of that. I work out of our San Francisco office, worked with companies from all over the place. So they can be US based, Bay Area based, East Coast based, or in other parts of the world where they're coming into the US to set up a presence and then to do financing, fundraising here in the US, and then develop and commercialize their technology or their products. I really enjoy working with companies, startups, and with investors as well. It's great to see the synergies between great company with great technology and the investors, and how they can come in and provide the capital necessary to really propel the startup on its journey. And also get a chance to meet with some really fascinating, very innovative founders and entrepreneurs that are coming up with just amazing ideas, technologies to solve really pressing, complicated problems, or in some cases, really simple problems that when you think about it, the question that comes to my mind is, wow, why didn't anyone think of that before? But nobody did. And now you've got someone that's created a technology that services that issue and solves the problem. And there you go, they're off to the races. Okay, so let's talk about a little bit about you. So I'm gonna go ahead and launch a poll, and then there's 3 questions. Take a few seconds. They're pretty easy. Do your best to go ahead and answer them. It'll give me some data pretty quickly about where you're from, what your position or title is with the company, and get me a sense of whether I need to adjust or pivot a bit on some of the discussion topics. So the first one is where you're located. Give you a few seconds to go through that. Answer which category is best. I mean, hopefully I've covered most of the categories. There's another category too. So if the specific region isn't listed, just put other. Okay, let's go to the next question. What is your role or title? So entrepreneur, founder, investor, etc. And the last question is, what industry are you in? So again, this will kind of give me a sense of where your business is, what sort of industry or area your business is in. Okay, so we'll take another couple of seconds, hopefully finishing out all that. And I know some folks are joining, so apologies if you didn't get a chance to go through the poll. Okay. Okay, so we'll give it a few seconds here. We're getting a few responses coming in, so I realize some people are joining. So for while we're waiting for the responses, if you are joining now, we're just starting. I went over the agenda. This is being recorded. The link for the recording will be made available to you. So sometime after the presentation, we'll make sure it gets out. So if you missed part of this, then you can always go back and listen to it. So okay, looks like we're still getting some answers coming in. So it looks like, let's see. If we've got a sense of where people are from here. Okay, so looks like good amount from the US. Okay, so let's look at the responses. Yeah, I'm seeing a couple people saying they can't respond to the poll. It's if the poll has already been done, then yeah, if you came in a little bit late or didn't get a chance to answer, then you won't necessarily see it. But and I'm not seeing the specific responses, so there might have been an issue with the poll as far as getting the information in here. Let's see. Yeah, we're still getting a few more people that are joining. Well, let's do this. Why don't we move on, because I can come back to that, and I'll be able to kind of check and see where people are and the different responses, and then can modulate. So, okay, so going back to the presentation, if you joined us a few minutes late, don't worry, we're just getting started. So let's go back here. So one of the first things that comes up when you're looking to set up your company with the idea of raising funding, initially seed funding, as we're talking about here, is a couple of things you should be thinking about. One is the entity type and the jurisdiction. So entity type is, there are a couple of number of different entities in the US you can choose from. Really, typically, you'll see most investors looking to invest in a corporation, a C corporation. There are LLCs and limited partnerships and partnerships, but by far and large, most investors understand, know, are comfortable with, and want to only invest in a C corporation. And setting up your entity properly with the right structure is going to increase your chances of making sure that you don't have a footfall and set it up in a way that's not attractive to investors. So if you set up an LLC, then you might automatically have eliminated a number of investors who just don't invest in LLCs. Doesn't mean you can't have one that will be able to raise financing in an LLC. We've certainly done it. I've certainly done it, but it's not very common, and a lot of investors just don't like that format. So setting it up as a C corporation is sort of one of the top things you should be thinking about. The second one that comes up is, okay, now I've got the entity structure. Where do I set it up? By far and large, and I'm sure many of you have already heard this, Delaware is the preeminent state for setting up your corporation. It is, they have a very sort of well-written, reviewed on a regular basis set of laws, especially the corporate laws, that people are very familiar with. So investors are familiar with them. A lot of the attorneys that work with companies, and especially startups, are familiar with them. And it provides for a lot of transparency and understanding as far as a long history of cases that have been decided. One of the other benefits is, in Delaware, if there's ever a business dispute, it will go to a specific court called the Chancery Court that only hears business disputes. So the judges that sit on the bench in the Chancery Court are very experienced, only hear business-related issues that come up. And so they oftentimes are very good at administering and rendering decisions because they've got a really good background and understanding of business laws that come into play. So very, very helpful. So investors typically like C corporations, and they like Delaware as a state. So if you haven't set up your entity yet, those are two things that will be really important. Okay. Whoops. Sorry, this is going a little too fast here. Okay. Next consideration, which I think is super critical. I see oftentimes founders and entrepreneurs make a mistake in not getting the documentation done properly. And so what do I mean, and what sort of documentation am I talking about? So when you set up a company, besides the corporate documents you need to form the corporation, you also need to be thinking about, how do I protect the company that I'm setting up going forward in a way that if people are developing things, creating technology, writing code, creating products, whatever the case may be, that's all captured and owned by the company, as it should be. So you want to make sure you've got confidentiality and IP assignment agreements in place with everyone, including the founders. And even though if you're a founder and you own all of the company, or if you and your co-founder own all of the company, you might think, well, I own it. Why do I need to sign this document? Well, it's important because the investors also want to know that all of the IP that relates to the business is owned by the company. And I've seen situations where two co-founders set up the company. One was the CTO, the technology person. The other one was sort of the business administrative finance person. The technology founder started writing code, developing the product, and then 6-8 months later decided to leave and go do something else. Never signed the documentation, making sure that the IP was owned by the company, which is the second bullet point on my list here, is the intellectual property assignments. And so that founder walked away still owning all of that, having rights to that. So now the company was really stuck because it didn't own the technology that it spent the last 9 months developing. It couldn't go out to investors and raise money because one of the investors' first questions is going to be, great, exciting technology, really interested in investing. Make sure you tell me that, and show me the documents that prove the company owns the technology. The last thing an investor wants to do is put money in a company and then find out that, oops, the technology that is really the valuable asset here isn't owned by the company. One of the founders developed it, left a few months afterwards, never signed the documents, and unfortunately, they still own it. So they're very easy agreements to prepare. We prepare them all the time for our clients. Easy to get in front of the founders when you're first forming it as part of the whole formation package, get them to sign it. It's also critical to make sure that employees and consultants that are coming to work for the company also sign these type of agreements. Seen situations where consultants come in, develop something, or early employees that are brought in to, finish developing the technology or what have you, that they come in, they don't sign these documents either. Then they end up leaving, and it's the same scenario. They leave with whatever rights to what they've developed are, and unless the company can get those assigned back to it, they're stuck. So those two are critical. Vesting of securities. So this also applies to founders, early employees, consultants, whoever you're giving any sort of equity to. So it could be stock, it could be options. You just want to make sure that you've got good documentation. It's done by a law firm that has experience in the area. There's all sorts of legal, securities, tax-related issues that come up. And it's not something that you want to go and Google a form, download it, and then use that without understanding and talking to a lawyer to help guide you through the process. But bottom line is, if you're giving anyone any equity, make sure that the documentation has good provisions in there so that if that person ever leaves, either leaves, is terminated, or something happens, that the company can buy back the shares that haven't vested, or if they're options that if they haven't vested yet, then they should just disappear, and then that person no longer has the right to have those options. That's critical because, again, as you bring in early employees and you're giving them stock or you're giving them options, you don't want people to walk away if they leave and they're not participating in the growth of the company, the success of the company. You don't want them to leave with owning that equity in the company unless it's been fully vested and they've paid their dues and put in their time. Then at that point, obviously, if it doesn't work out and they leave, they've at least fulfilled those requirements. So super critical to make sure that's in place. And then transfer agreements is another topic that's important to think about too. So whether you have shareholder agreements, this could be between the initial shareholders, it could be between the initial founders, just to how are we going to manage, govern, control, make decisions about the company. So oftentimes, as you get further on in the life cycle of a company and you've raised some rounds, there will be documents that the investors will require that will provide for some of this. But before that happens, if you've got a couple of co-founders, that's something you should at least be thinking about and talking to your counsel about is, should we have a shareholders agreement? Do we have an understanding as to how we're going to manage and grow this company? So I've certainly seen that to be an important piece as well. You can have restrictions that are built into various documents, such as your bylaws. You should have stock purchase agreements to evidence the purchase of the shares, even from the early founders. Sometimes they're referred to as a subscription agreement or a stock purchase agreement. But regardless, there should be some documentation. Because again, thinking forward to when the investors are looking at your company for that initial seed financing, they're going to want to know that all of your documentation is in order, that the people that own shares can actually support their ownership by providing documentation, that they own the shares, that people have received options, have received them properly with the proper documentation, all of that. So very critical to make sure that not only from an internal governance perspective, but also from a diligence perspective from the investor side, that you can answer questions and evidence all of the things that the company has done and that it's been done properly. Okay. Let's talk about next topic, financing options. So I'll go more into detail about the convertible debt, convertible equities, so convertible notes or safes, which is what we're going to be talking about primarily. There are a couple of different options, actually more than a couple. So there's convertible debt, which typically when you think of that, that's your convertible note, convertible promissory note. Convertible equity can have a couple of different forms. The one I'm going to be talking about today is the SAFE, which stands for Simple Agreement for Future Equity. And then, of course, you've got your equity where you're actually selling stock, and it could be shares of preferred stock, which is usually more typical, or it could be shares of common stock, which sometimes companies will do to raise money, although not very common, and there are some problems with doing raising financing that way. Other options that are beyond what I'm talking about today, there are grants that might be available depending on the kind of technology and industry you're in. There might be, you obviously there are the loans you can take out at some point in time. Usually, if you're a little bit more advanced in the process and you've got something that you can put up as security, then you might be able to take out a loan. But those are your basic options at a sort of a high level. Okay, let's go to the next slide. Okay, whoops. So when we talk about convertible securities, the basic concept is it's a type of security that's going to convert to equity securities or shares, for example, upon some event happening in the future. So usually we talk about it being a qualified equity financing. So at the point in time when you then go and sell shares, and if it's a qualified equity financing, and I'll discuss that in a moment, then at that point, the convertible security converts into shares that are sold at that qualified equity financing or that next financing. So there are some pros and cons with convertible securities. The pros, which are pretty obvious, are there obviously avoids having to value the company because you're not actually selling stock at that point in time. You're selling the right to purchase stock at a future date. So you don't need to actually price the stock on the day you go ahead and issue a convertible note or a SAFE. You can push that valuation down a little bit further. And in light of the economy today and the landscape, and I'm sure everyone who's been reading the news and watching what's been going on in the markets, in the startup ecosystem, valuations obviously have come down a bit. investors are being more careful and more selective in their investments, and have been challenging some of the valuations that the companies are positioning for. So may not be a great time to go out and do a what we call a priced equity round, where you actually sell stock and you come up with the purchase price on that stock. If you can avoid that and push that down a little bit in the future, that may be a good strategy. So convertible security allows you to do that. So that's one of the pros, obviously. Other pros: easy to document, a lot less expensive than doing a priced equity round. For example, and I'll talk about this a little bit more, if you're issuing a SAFE, and there's some great forms on Y Combinator's website that are sort of the market standard form of SAFE. Those are, I think those are 4 pages. So very short, very easy to put into place, doesn't require a lot of negotiation back and forth, makes it a really great tool for early investment in a company. Easier, quicker to process, all of that as well. Some of the cons, in particular for convertible notes, keep in mind that it is actual debt. So you are borrowing money from the investor. Typically, investors do not want to get repaid in cash. They are looking to make an investment that in the future will convert into equity in that company, because they're looking at the long term. I want to invest now. I'm not interested in getting my money back. I can go invest it if I want to, get interest and all that. I'm really looking at investing in a company that's going to grow, and at some point in time there'll be an exit, and I'll convert at some point in time, so I'll have shares. So when there is an exit, I'll be able to realize a really nice return on my investment. So typically they're not looking to get repaid, but it is debt, it is a loan, and so per the terms, it is required to be repaid. Usually we see about a 3-year period. It could be shorter, a little bit longer, but typically you'll have a maturity date of about 3 years. So the company's got 3 years to use the capital, build, grow, to get to a point where it can do a qualified financing, which then that note would convert into stock, and you won't have to worry about repaying it. I call it an extra liquidation preference, because especially for notes, if it is a note and a loan, it's considered debt, and the holder of the note, the investor, is considered a creditor, and creditors always get paid first before the shareholders. So it's a negative for the company, but it's a positive for the investor. So some investors like the convertible note feature because it gives them the status of being a creditor, and that if something were to happen and the company were to get dissolved, then at least they're closer to the front of the line and will get paid out before the shareholders will get paid out. So it gives them a little bit more protection, if you will. Conversions can be confusing. We'll talk a little bit about this. So both SAFEs and convertible notes have this conversion feature I've been talking about, which essentially has the instrument convert into shares at some future date when there's a qualified financing. And there's all sorts of, terms and provisions and conversion features that come into play, and tracking that and calculating that out can sometimes be confusing. So we'll talk a little bit about that as well. The other thing to keep in mind that sometimes can be a negative is if you go out and give notes or give SAFEs and don't really know what you're doing, or don't negotiate good terms, you can sometimes end up giving really sweetheart deals to the investors. And what I mean by that is that they can end up getting a tremendous discount on the price of the stock eventually when the stock is sold. So for example, simple illustration, if you were to give someone a convertible note, $1 million investment that essentially says, when you next do your qualified financing where the note will convert, whatever the price is that you're going to sell your stock at that next financing, I'm going to get a 50% discount. We don't see that. It's very unusual. That would not be market term. But for illustration purposes, that means that when you have your next financing and you go out and sell stock to investors, that note holder is going to come to you saying, great, I'm going to convert. And by the way, you're selling stock at $2 a share in this financing. I get to buy it for for $1. So I'm essentially getting a 50% discount. That can end up giving them a lot more stock. It gives them a much better bonus, as far as getting a sweetheart deal, which is maybe something that you want to avoid. So something to think about. Okay, so my computer's a little slow today, so let's go to the next slide. Okay, Other aspects of convertible securities, we talked about conversion. So conversion can come in a couple of different flavors, but typically you'll see some sort of mandatory conversion or auto conversion at the next qualified financing, which is what I've been talking about. And it oftentimes will include some sort of discount to the price that's being sold at that next financing. One thing that's important is to look at in the documentation, how is qualified financing defined? And it can be defined a number of different ways. We oftentimes see either in the SAFE instrument, which we'll talk about, the YC Combinator SAFE form has a pretty simple definition. It's, the next time you sell stock to purchase, for purposes of raising capital. It's a very, very broad description, very broad definition. So it's going to capture a lot of events that might occur for the company where they're going out and selling stock that will then trigger the conversion of that SAFE. But we also see on a fairly regular basis too, where the qualified financing is defined to have a certain threshold. So what that means is the company has to raise a certain amount of financing in order for that conversion to be triggered. So as the example in my slide says, minimum size of 2 million. So the company has to go out and raise at least 2 million by selling shares in order for that to be considered a qualified financing, which would then convert that security, whether it's a SAFE or a convertible note. The discounts you need to really pay attention to. So they come in a couple of different flavors, if you will. One is just referred to as a discount or discount rate. And essentially that means that whatever the price of the stock is that is sold at that next qualified financing, the note holder or the SAFE holder gets a discount to that price. So in my example I gave earlier, if the next qualified financing, the stock is being sold at $2 a share, and if they're getting, the example I gave was a 50% discount, then they would be able to get that stock upon conversion at $1 a share. So you would do the math to figure out at $1 a share how many shares they would get. And essentially they'd get that much more shares than the folks that are buying it at $2 a share. Typical rates that I see that are reasonable, anywhere from 20 to 25%. Sometimes we've seen a little bit lower, sometimes we've seen a little bit higher. It would be unusual to go any higher than that. Usually it's between 20 and 25% is pretty typical. The other type of, I call it a discount, even though we don't really refer to it in that term, is what's called a valuation cap or a conversion cap, price cap. And that's another way that you calculate the conversion of the investment in a SAFE or in a note into shares at that next qualified financing. And essentially what you're saying is the note holder or the SAFE holder is going to give a certain value, and that value will be used to calculate the shares that it will convert into. If the company at its next qualified financing has a valuation that's lower than what the valuation cap is, then you would use that because that'll give you a better deal for the SAFE holder or note holder. If, however, the company goes out and wants to sell stock but prices it at a valuation that's higher than the valuation cap, then you would use the valuation cap because, again, for the note holder, the SAFE holder, you're going to get a better deal and you're going to be able to get shares at a better discount to what the folks in the qualified financing are going to be paying. Conversion upon a change of control or sale, there are provisions oftentimes in either a note or a SAFE, or if the company is sold or there's some sort of change of control, that can also trigger conversion. There can also be a conversion at maturity, which you'll see sometimes in convertible notes, where if the note's not paid off within a certain period of time, that once that maturity date arrives, then there's either an option for the note to be converted into shares, or the note holder automatically has their note converted into shares. Okay, so let's go on to the next convertible notes. So now we'll talk a little bit about convertible notes in particular. These are some of the typical terms you'll see in a convertible note. So maturity date essentially is when the note is due. So typically, again, we see about 3 years being fairly average. It could be shorter or longer, but that's when the note has to be repaid. And you typically want to set that date far enough in the future so that you know you've got enough of a runway, if you will, so that there's a good chance that you'll be doing your next qualified financing before that maturity date so that the note can convert. You don't want to be in a position where you don't raise funds, the 3-year mark's coming up, and now you're stuck because either you have to give them their money back and interest, or you then at that point have to convert them. And depending on the language you have in your note, if the note holder has the option, if they decide, yeah, it's great, I'm really not interested in converting into shares, I just want my money back, then you can be in a bit of a bind, especially if it's a large amount, because you've got to then repay that note holder. Interest rate, we've seen these all over the place, but anywhere from 4 to 6 to 8%. Obviously, with interest rates having gone up, we've seen a hike up in the interest rates that are being charged on some of these convertible notes as well. The valuation cap I talked about, that's used to calculate the conversion of the amount of the loan into shares at next qualified financing. The discount we talked about as well. Conversion terms, basically that's either automatic or at maturity. There could be other provisions about when they convert, change in control that we talked about too. But for convertible notes, typically it's at the next qualified financing or once the note matures. The other aspect that's important to at least be aware of is whether or not the note is secured or unsecured. And security basically means that the loan is being provided to the company and it's being secured against whatever the security is, oftentimes whatever assets of the company that has. So that means that basically there'll be a lien on the assets of the company. You can't sell or transfer those assets without getting the lender's consent. And if in the circumstance where the note has to be repaid or can't be repaid and there's a default, then the note holder, the lender, can actually go after the assets that are secured by the loan. Don't see those as often, although have certainly seen where we've done convertible notes that have been secured. The more common type of convertible note that I see is unsecured, meaning there's no security of any collateral. It's basically unsecured. So if the company can't pay, the lender can go after the company, but they don't have a lien on any assets that they've secured that gives them a better rights or more protection. Default is another area you want to be concerned about, making sure that you understand what the default terms are, provisions are, just to make sure you don't accidentally trip over a default. Obviously, the main default most people think about with a note is not paying the note on time. But I also, would encourage everyone to make sure they also look at other things. It could be not providing certain information. It could be the information you provided was untrue or incorrect when you provided it. This is misrepresentation. That could trigger a default. You just want to make sure you understand what those terms are so you don't accidentally trip over them. Representations and warranties. You'll oftentimes see some representations of warranties from the company, but also from the investors. And typically they're usually pretty straightforward, but really want to make sure you pay attention to those and understand them, because from the company side, you have to make sure that everything that is being represented and warranted is true and correct. And if there's any issues, you need to make sure that gets addressed. The other thing you'll see oftentimes are amendment terms. So how and when can the notes be amended? And do you need everyone to, do you need all the note holders if there's multiple notes to amend the terms of the note, or if a majority of the note holders can amend the terms? And that's an important concept too, because with convertible notes, you can go out and do an offering of convertible notes where you go out to multiple investors, offer them the same terms essentially, and you document that with what's typically called the note purchase agreement and then the note itself. But if you've got 10 or 20 people that are providing convertible notes, what happens if at some point in time you need to make an amendment? So for example, you go out, you issue 10 convertible notes to 10 investors. You have a maturity date of 2 years. 2 years, you're coming up on the 2-year mark. You've been talking to some investors to do your qualified financing, but it's going to take a little bit longer. So you need to actually get more time on the notes. So you can go back out to the note holders, get them to agree to extend the maturity date. If you don't have the right language in your agreement, then you basically have to go out to all 10 investors, get all 10 to sign up and agree to extend the maturity date. And if one of them doesn't want to, then you've got a bit of a problem, because then you got to deal with that person. Can't extend the maturity date, you got to pay them. But if you've got the right language in there that says we can amend the terms of the note as long as we get a majority of the note holders or a majority of the amount that's been loaned, then as long as you go out and get that majority, then you can amend the notes and extend the maturity date. So important piece, because it can certainly help the company if you do need to make certain changes. Okay. So let me go back here. Okay, we talked about that. So let's move on now and talk about safes. And the SAFE, I think I mentioned the acronym stands for Simple Agreement for Future Equity. It was introduced by Y Combinator, which I'm sure most or all of you know, back in 2013. And it was really created because there was a lot of frustration over the length of time and the fees that were being incurred by a lot of companies, especially at the earlier stage of the startup, in having to go out and do a priced equity round, so sell preferred stock. So Y Combinator came up with this alternative, and it was an alternative to convertible notes too, because they made it even simpler than a convertible note and made it super simple form. I think I mentioned it's 3 or 4 pages, made it very easy to negotiate, made it very easy to put into place, and allowed for a much more easy way to go out and get early stage financing. The nice thing about it is it is not a note, which means there's no maturity date, there's no interest. It's not treated as a loan per se, at least not from the company's perspective on the balance sheet. It doesn't show up as debt on the balance sheet, and that way it makes it even that much more attractive, especially from the company side, because it's easy to get these done, it's easy to put them in place, and you can get cash very easily. I mean, on a very quick time scale, you could, if you needed to, get one of these put into place in a few days. It wouldn't take a long period of time, as long as you had everything, all of your ducks in a row, if you will. So simple form, cost effective, not treated as debt on the company's balance sheet. It avoids the repayment because it's not treated as a loan. And it also gives the founders more control of the capital. So you're not selling stock, so you don't have shareholders. And because it's not debt, you don't have a creditor there who in some cases can dictate how the money is going to be used. And basically they're giving you the money, the company can use it how it needs to use it, and you have a little bit more control over that. Okay, so the next slide, let me see if we can. Okay, so one sec here. Oops. Okay, so we talked about Y Combinator and the safes. So other things to be thinking about when you're talking about safes, or some of these terms you'll see. Valuation cap we talked about. With safes, there are 2 flavors, if you will, where there's a pre-money valuation cap, or pre-money safe, or post-money safe. The pre-money safes were the initial safes that Y Combinator came up with. Those have been phased out. I don't know exactly the date. I think it's been about 2018 or so. So when you go to the Y Combinator website, which I would certainly encourage you to go to, because they've got a lot of great information, including some articles and some information about terminology to help you really understand the safe. But the forms that are now available there are all post-money safes. I'll talk about that in a moment. But basically, you'll see the valuation cap, the discount rate, which we talked about, which is essentially the discount off of what the price that the stock will be sold, the next financing will be. There's also a provision that you might find in some of these safes that referred to as MFN, or Most Favored Nations provision, which essentially says if you go out and issue more safes or other securities that have better terms than what you're giving to me, then you've got to also provide those same terms to me. So as an example, if you have a safe you've given to an investor that has this MFN provision in it, then let's say in a few months you go out and you give, and the safe you issued had a 20% discount. Then you go out in 6 months and offer another safe, but this time you give the investor a 30% discount. If your initial safe had the MFN provision in it, you'd have to take a look at that. But essentially what you may have to do then is go back to the first safe holder and say, hey, by the way, we just issued a safe that's got a better discount. So because of this MFN provision, we're now going to amend your safe to give you that same additional discount. So it's really nice for the investors, not so nice for the company. We don't see it as often, but again, something to be thinking about. There is a form specifically with that provision in it that's on the Y Combinator website. Okay, conversion terms. In the safe, you'll see that the terms upon which the safe will convert. And again, usually the one that people focus on primarily is when is the next qualified financing or next equity financing, which will then trigger the conversion of that safe. They're all intended to convert because that's how the investors are ultimately going to realize a return on their investment. It's not by holding the safe. They're only going to get really repaid when the safe converts into stock in the company, and then at some future date in the company, the company will have some sort of exit, whether it goes public or whether there's a sale, and there are proceeds. Those proceeds get distributed. If the safe has been converted into stock, then they would share in those proceeds according to the terms of the charter and the agreements they have that are in place. Reps and warranties, similar to a convertible note, you'll oftentimes see reps and warranties. The Y Combinator form has a set of reps and warranties from both the company and the investor side. The other thing you'll see oftentimes either built directly into the safe instrument itself or built into a separate side letter is what's referred to as pro rata rights. It can also include other rights, but most of the time we'll see the pro rata rights built into the safe or side letter. And actually the Y Combinator website has a separate side letter agreement that has these pro rata rights built in. And essentially what it is it gives the investor the opportunity, if the company goes out and sells, issues more safes or is going to issue more securities, that they would have the right to also invest and keep their same percentage or same potential percentage at the level that it's at now. So it's a nice to have for the investor because it allows them to keep their investment in a certain place or percentage. It also is important if you actually have a conversion and now they've got, let's say, 3% or 4% of the company. If they have pro rata rights, when the company goes out and sells more shares, does another round, that they can then have the opportunity to buy more shares to keep them at that same percentage that they had. And that sometimes is important to investors. Some investors want to make sure they're maintaining a certain percentage of ownership as part of their investment strategy. So that's oftentimes something you'll see that is important to be aware of. We're seeing more and more of these safes also negotiate for additional rights, such as major investor rights or information inspection rights, board observer rights. So those are where investors are asking for more rights. Information inspection rights, somewhat self-explanatory as far as it gives the investor the right to get certain information about the company, books and records, cap table information, business plans, budgets, things like that. Or inspection rights, similar in the sense that they get the right to inspect records, or also in some cases the right to inspect the actual premises or facilities, what have you. So we're seeing that being negotiated a little bit more, or ending up in these type of safes a little bit more often than they were previously. Okay, let's go to the next slide. Okay. We can get to the next slide here. Okay, foundational basics. So I want to talk a little bit about this. It's important in planning, down the road as far as what the company is going to look like, different stages as you raise financing. If you do your seed financing and you're issuing a convertible note or a safe, as I mentioned earlier, you're not issuing stock. So the investors are not getting stock in the company. They're not going to have an ownership of the company. They will have the right to acquire stock at a future date and they will have the ability to have an ownership interest at a future date when it converts. So even though they're not going to have ownership on the date they get the convertible instrument, the note or the safe, it's still important to be thinking about this stuff, because as you're negotiating or deciding what to offer, do I offer a 20% discount or a 25% discount? Do I offer a valuation cap that's 5 million or 10 million? All of that's going to come into play once that convertible instrument converts into shares at a future date. So planning for that now, or at least as much as you can plan for it now, is going to be a really helpful exercise. And you know, even though you don't know exactly how many shares are going to be sold at your next round, most likely, you can still make some assumptions and run some numbers and create a pro forma. So you can kind of see, if I go out and raise, you know, $2 million in 2 months by selling Series C preferred, and I've got these 4 or 5 safes, then let me run the numbers and see what they're going to convert into, so that I can get at least a snapshot of what the valuation will look like, the dilution that's going to occur for the company, the founders in particular, and I can kind of at least be thinking about that as I go out to negotiate these terms. I've seen some people that, you know, founders that don't do that, haven't thought that through. And so when they go out and offer terms, they'll offer, okay, I'll give you 25%, or I'll give you a 30% discount, or they'll set the valuation cap really low. Maybe they set it at 2 million, even though if you look at sort of similar companies that have gone out to raise financing, you know, you oftentimes maybe could come up with a number that's maybe 10 or 15 million on a valuation. Well, by setting it so low, they're basically giving the investor a sweetheart deal. As I mentioned earlier, they're going to be able to get stock at a highly discounted amount compared to what the investors purchasing the stock are going to get. So the net effect of that is they're going to get more stock, which means there's going to be more dilution to the founders. So it's something you kind of need to keep track of, and thinking about it now is going to be a great way to plan for it. So think about the ownership, the control, think about the dilution, because it's definitely going to happen. And you know, also as part of that is, okay, how am I incentivizing my team? If I've got an equity incentive plan, what am I deciding as far as who gets options, who gets stock, how much, to make sure that they're incentivized? Because without a great team that's incentivized, you're going to have challenges as the company grows and scales, and you want good talent. And then, of course, having proper documentation. We talked about vesting, we talked about repurchase rights, making sure the documentation's there to protect the company, so that if some event occurs, you've at least built into the documents as much as you can to protect against certain outcomes. And I think I gave you a couple of examples with a co-founder walking away, never having signed the documents, assigning the assets over. So now they walk away with the most valuable asset of the company. Okay, let's change to the next slide. Okay, so some more foundational basics, and you'll see these terms coming up oftentimes: pre-money valuation, post-money valuation, issued outstanding basis, fully diluted basis. It's helpful to just know generally what these terms mean. It'll be really helpful and critical, in fact, when you're doing your SAFE or your convertible note financing. So pre-money valuation, that's the value of the company before your next round of investment. So before you've taken in the investment, what is the company worth? Post-money valuation, what's the value of the company after you've taken in the investment? So if you've got a valuation, pre-money valuation of 10 million, you're going out and getting a $3 million investment. Your pre-money valuation is 10 million, post-money valuation is 13 million. Issued and outstanding basis, or what is the issued and outstanding shares in the company? It's all of the stock that's currently issued and outstanding. So whatever stock has been issued already and is outstanding and held by stockholders, that's what your issued and outstanding stock is, or issued and outstanding basis is. That doesn't include your options. It doesn't include convertible securities, as we've been talking about. So it doesn't include safes. It doesn't include notes. It doesn't include options, warrants. It's just purely what shares have been issued and are currently outstanding. The next one that's important is to understand is fully diluted basis, which essentially is you take all the stock that's issued and outstanding, and then you add to that all of the securities that can be converted into common. So that's typically options, warrants, can include convertible notes. because that'll give you a snapshot of if everything is exercised, if everything's converted over, what's the ownership of the company look like at that point. And the real, important part of that is yes, important to look at, the safes and convertible notes, but oftentimes it's looking at issued and outstanding. And then if you've got an equity plan, how many shares are reserved under the equity plan, how many options are out there. And if everyone exercise all of their options, all of those options have been granted and exercised and purchased, what does that snapshot of the company look like? So fully diluted basis, it can be defined differently. So it's really important to look at how it's defined in the applicable instrument that you're looking at. So for example, in the SAFE, there will be, I think they call it company capitalization. So you'll need to look at how that's defined, because that's going to be what you'll use to calculate when your SAFE converts. You need to be able to use that in calculating what it's going to convert into. You need to know that number. And the same for the convertible notes. If it's defined, sometimes it means issued and outstanding stock, equity, all the plans under an equity incentive plan, options, etc., and warrants and safes and convertible notes. Sometimes it doesn't include all of those. So it's really important to understand what that means based on the instrument you're looking at. Can we go to the next slide? So let's look at foundational basics. Just a really quick, simple example, just to kind of put this, to illustrate this for you. And I'm not factoring into this option pool or any equity plan. So if you have a pre-money valuation of 10 million, you have 10 million shares split among 3 founders. So founder A, each of the founders is going to have 33%. Founder A will have 3,333,333 shares. So let's say then the company is going to have an investment of 3 million at $1 a share. Because if you take the 10 million pre-money valuation divided by the total number of shares that are outstanding, the 10 million, that gives you your $1 a share. The pre-money we talked about is 10 million. The post-money valuation is going to be 13 million, right? Because you're taking the 10 million pre-money valuation that you've determined, you're adding the additional 3 million investment, and now you're coming up with a $13 million post-money valuation. So if you look at now founder A with the shares that they own, they're going to end up owning approximately, after this investment, 25% of the company. So you take the 3,333,333, the number of shares divided by the post-money valuation, that gives you approximately 25 and change percent of the company. So you can see how the dilution works, how to factor in what the added investment means with regard to the ownership interest. It went down from 33% down to 25%. Can we change to the next slide? Okay, so another example. Whoops, went one too far. Let me go back one. Okay, so now we're looking at convertible securities. So let's say there was a convertible security. The amount of the investment was 450,000, and the security had a 25% discount, and that was the term that it had. So essentially, upon conversion, applying the discount, the holder would receive 600,000 shares. And so if you do the math there, you take the money divided by the discount, and then by the multiply it by the purchase price per share. That's going to give you your 600,000 shares. So you can see that a $400,000 investment in this scenario with a 25% discount will result in the investor getting 600,000 shares. Second scenario, same investment amount, convertible security, but now instead of a discount, they have a valuation cap of 5 million. So in this case, when you look at the example, and let's assume, this assumes a $10 million pre-money valuation, which is what we've been using in the examples. So applying the valuation cap at 5 million, this scenario ends up with the investor getting 900,000 shares. So when you do the math, applying the valuation cap, and the reason why you apply the valuation cap is because that number is lower than the pre-money valuation. Pre-money valuation is 10 million. The valuation cap is 5 million. So then you have to use the valuation cap in calculating out the price per share number of shares. That ends up with an additional 300,000 shares that the investor is going to get. So when you're going through and figuring out, how to do this and what to offer, run through some of these scenarios, because you can clearly see giving a discount from the company's perspective means you're going to end up giving out less shares in this scenario than if you gave them a valuation cap. They're going to end up getting 300,000 more shares. Now, again, the investor is also going to dictate what they want, but to the extent you have some negotiating room, have some negotiating ability, and oftentimes with your sort of initial seed financing, if you're going out to people that you know, friends and family, or people you have relationships with, you might have more flexibility and more ability to negotiate some of these terms than not. So looking at the difference in what you offer can make a huge impact on your cap table. Can we go to the next slide? So I'm going to, and we're at 10 o'clock, so I want to reserve some time for Q&A. So I want to just talk generally about overview of seed financing. We've talked about some of the details and, convertible notes and safes and all of that. But here's some general information that I think will be helpful. So obviously you have to have a credible business plan. You need to make sure that the business plan is tight, that you've gone through it, you've reviewed it, you've had other people review it, but try to get people to review it that have been involved with startups that have gotten funded or have been investors and reviewed business plans. So you can really get some good feedback on what's important, what's not. You want to make it as concise as you possibly can. So it's the most attractive it can be to the investors. You've got a short period of time to really get the investors' attention. So make sure that the business plan is set up to be successful. Run a systematic process. So what do I mean by that? Know how much capital you need, how much you need to go out and raise, how long that's going to last you. If it's going to last you a certain amount of time, are you pretty confident or comfortable that you're going to be able to raise the next round within that time period? Do you need to adjust those numbers or that timing accordingly? Connect with the right investors. The shotgun method oftentimes is not the most successful method, because you might be talking to some investors that don't invest in your space, don't understand your industry, or don't invest in the stage of company that you're at. So doing it at that point is not going to be very successful for you. Talk to the investors that are going to be the right investors. Understand your ideal term sheet. We'll talk a minute about that. Prepare for your diligence. Make sure everything's in order. Your documents are there. That you've got an organized data room. You've actually saved the documents in a way that people can read the title and know what it is. Do whatever you can to make that as efficient a process as possible. Good corporate hygiene, which is exactly that, making sure you've got documents, they're dated, they're signed, they're organized, they're in a place where they can easily be accessed. They're in a format and structure where investors are typically looking for them and expect them to be organized. And then be prepared for cleanup. There may be issues that come up. Investors say you need to revest your stock because you've been at this now for 4 years. All your stock is vested, but we don't want to put money in the company unless we know you're going to be sticking around. So we want you to go back and revest some of your stock, because we want you as the founders to make sure you're going to stick around. You're not going to just take off because all your stock is now vested. So you could easily take off with whatever percentage you have, let the company go, ultimately goes public or sells, makes a ton of money. You haven't been involved in the last 2 or 3 years, but you still get a windfall. Investors don't like that, so you may have to revest. So some of the cleanup stuff, be prepared for. And working with your attorney, they can flag some of that stuff early on, get it all cleaned up, get it taken care of. So when you get to the point where you're starting to talk to investors, that's all done. Don't have to worry about doing it at that point. Can we advance to the next slide? Okay. I'm not going to go through these too much. We talked about a lot of this stuff, so let's skip over to the next slide. So just general overview. So high level, you'll have a term sheet. Once that's signed, there'll be a diligence process for safes and convertible notes. Expect diligence. It may not be as extensive as if you're doing a priced equity round, but you still need to be prepared for it. Make sure you've got the documentation process underway. If you're using a safe, are you using the Y Combinator form of safe? convertible notes, there isn't like a go-to site that has the sort of the market leader of a form of convertible notes. Everyone has their own. A lot of times your law firm will have a form of note that they've used, that they've negotiated and worked on, that they would propose using. There are some sites where you can go get samples of convertible notes to look at, but that's because those are a little bit more negotiated. I would think you want to make sure you talk to your lawyer and get a good form from them, have them help you with that. Plan for pre-closing. Are there pre-closing items you need to attend to? If you've gotten a loan, if you have loans out there, if you have some agreements out there where you're going to need consent or approvals to do this financing, make sure you know that up front so you can go and get that in advance and it doesn't become a delay on the closing. And then making sure you've done everything so you can get through the closing as quickly as possible. Post-closing items, there may be some post-closing items that you'll need to take care of. If, for example, you've got a few shareholders and you've only gotten the two founders who control 80% of the shares to approve everything, you're going to typically we'll go out and send a notice out to the shareholders that didn't consent, just letting them know what happened. There's all sorts of other things post-closing, making a closing set, getting the stock certificates issued if you're issuing shares. In our case, with notes and safes, there is no stock to issue. So it's basically just making sure you've got all the documentation, it's all signed, dated, organized. And then what's helpful for safes and notes is to keep a matrix, keep a spreadsheet of every one you've issued, and go through and actually, go through and have the discount rate, the valuation cap, the amount of the note or the amount of the safe, and some of the other terms, so that you've got a spreadsheet that you can then easily take and use to calculate out what they will convert into once you do have your next round coming up. Next slide, please. The last thing I'll say here is just when you're getting ready to close your seed financing, I always like to think of the ABC rule, which is always be closing. So from the day one that you sign your term sheet, just think forward and then start working backwards. So think about the closing and then work backwards to get everything in place that you need to have a successful close. We talked about all these things, so I'm not going to go through them again. But just make sure you've got everything as organized and you prepared as much as you possibly can. Next slide. Okay, so running through some common pitfalls that I've seen, and these aren't necessarily specifically for convertible note financing, your seed financing, if you will, or safes. It's all the stuff that typically I've seen that takes place before that can cause bumps in the road as you're starting to go to raise financing. And we've talked about this before, earlier on this presentation, not structuring the entity properly, not having proper documentation, not making sure that the company owns the IP that has been developed, having undocumented stakes in the company. So what I mean by that is early on, you're sitting down with some friends, you hatch out a plan on the company, and you basically have a deal with one of your friends that says, hey, look, I want you to be involved. Why don't you help me out? And you can have 20% of the company. And maybe you have like an email back and forth or a napkin or some piece of paper where you kind of scribble on, all right, you're going to get 20%, I'll have 80%, and we'll do this. You never really formalize it in an actual formal written agreement. But it doesn't show up on your cap table because you forgot about it. 6 months later, when you then form the company, you forgot that you'd actually given 20% to your friend. That would be an undocumented stake in the company, because at any given time, that friend can come back to you saying, well, wait a minute, I thought we had a deal. You gave me 20%. We had those conversations. I helped you brainstorm, come up with this and that, and I want my 20%. That can be a big issue. Not managing the cap table properly, not keeping track of who's got what, what safes, what notes, what warrants, what stock. It can get messy if you don't keep it controlled and organized. Not understanding the terms, using boilerplate, or just pulling a form down from Google, assuming, hey, it's a form, it should be fine. Not getting proper corporate authorization. So keep in mind, when you go out to raise your financing, you need to get board approval. You'll need to get, if you're going to be filing an amendment to your charter, or if there's other agreements in place that require the stockholders to consent, you'll need to get stockholder consent. So there's a lot of other things that I've seen where people either don't pay attention, they don't get good advice, and then they end up making a pitfall. Next slide, please. Okay, so just a couple of thoughts. Do your homework. I can't emphasize that enough. Prepare in advance. I've seen the best chance for success where you really prepare, ask the questions, talk to your lawyers, talk to your advisors, talk to people who have been through the process before. get the best sense of all the things that might come up, and then start working on trying to eliminate those from coming up in your deal. And that will give you the best chance of not having some of these common pitfalls that I talked about a minute or so ago. Okay, next slide, please. Okay, so here's my name, my email. You can reach out. So, and I know I'm a little bit over, but let's open it up for some Q&A. I'm going to run through the comments now, and I'll try to answer as many as I can. Admittedly, I may not be able to answer all of them, but I will certainly do my best. Okay. All right, so can you register in Delaware even if you don't have a residence or office there? Yes. A lot of companies will register in Delaware. You don't have to have an office or a presence or anyone in Delaware. Basically, you can form the company in Delaware, and then you will use a service, a registered agent that acts as your, agent in Delaware. So if there's ever anything that gets served or a notice that needs to be sent, there is a place in Delaware where it can go, and it's usually a service company that does that routinely, and they can also help you with filings and things like that. So no, you don't have to have a presence there. Okay. Yeah, we will definitely share the link for the recording, so you'll be able to get that. Some people ask me how they can contact me. If you look at the slide that's currently on, my email's there. Feel free to reach out. You can look me up on Foley.com or LinkedIn. Another question, if safes are so great, why would companies ever want to raise any other way? Well, that's a good question. So investors that are coming in usually could be early stage, but when you do your first price equity round where you're actually selling stock, you can't use a safe because the safe is not an instrument that is suitable for issuing stock. I mean, it's not, you can't get stock when you issue a safe. A safe is basically a right to purchase stock in the future upon certain events happening. So if you actually are selling stock, and some investors are going to want to buy stock, they don't want a safe, they don't want a convertible note, because if you're buying stock, you also get all the rights that come with owning that stock. So voting rights, protected provisions, liquidation preferences, all sorts of things can be built into the company charter document that will ensure that type of stock gets those rights. And that's typically what a lot of investors are looking for. So that's one reason why safes are great. They're easy. They've got all the pros I mentioned, but it's not like buying stock in a company. So investors that want all of the things that come with buying stock are not necessarily going to be the ones that want to invest in a safe. Some will do both. Some will invest early on with a safe, and then once the next qualified financing comes up, they may also invest in that and buy stock and also have their safe convert. But that hopefully answers that question. Okay, well, someone posted something about safes may not being the best. I mean, yeah, certainly read that. I mean, there are definitely pros and cons. It's not for everyone. It's not for every startup or every circumstance. It's one option that can be very easy and effective to put in place. And it is used on a regular basis. I've seen them over years and years of having done this. And so it's definitely a tried and true method, but it's not necessarily the only method or the best method. It depends on the circumstances. Okay, do you see investors okay with founders using funds to set up a holdco, or do they insist on having one set up before they invest? For bootstrapping founders, setting up holdco can be very expensive. That's a good question. I often say if you're developing your tech, you're developing your product, your idea, whatever the case may be, and you need to focus on doing that, and you're not going to be going out and raising financing, you're not going to be going and signing agreements with vendors and suppliers or customers, you're just doing the R&D, then at that point in time, there's no need to form the company yet. So I would wait, save the expense, wait until the point in time when you have a product that you want to go out and commercialize, start selling, doing pilot programs, what have you. You are in a position where you need to take on investment, or you're now at the point where you're going to be hiring employees, you're going to be engaging consultants, or you need to start working with vendors and suppliers and other parties. Any of those points are good times when you should be forming your company. And the primary reason why is if you're going to be hiring employees, consultants, signing agreements with vendors or distributors or what have you, or even with customers, you're going to want the protection that a corporation offers, because then, your own personal assets can be protected. The other reason is, obviously, if you're going to go raise financing, the investors they're going to invest in an entity, as we talked about. So that then you absolutely have to form your entity at that point in time. The only other caveat I'll mention is, if you're going to go talk to investors and you haven't set up your company, that can display a lack of commitment to your venture. So you also want to avoid giving the wrong message. Some investors will look at that and say, look, you're not even ready, so why are you even talking to me? When you get everything set up and you're ready to go, then come and talk to me. And keep in mind, oftentimes you'll have one shot with some investors. If you don't get them interested, then you're not going to get a second chance. So if they're the type of investor that expects it done before you come talk to them and you don't, then you may have just closed the door on that potential opportunity. Another question: from an investor's perspective, how much do the investors value purchase LOIs during evaluation or franchise models of interest? How many are interested in impact investing? That's a good question. So let me talk about the impact investing. There are funds that are really focused either solely on impact investing or have a particular interest on impact investing. And usually, if you get to know them, or if you go and look at their website, you can get a good sense of what their interests are. They're either focused on a particular industry or sector, or something that's related to impact investing or social impact or what have you. So yeah, there are quite a few out there that do impact investing. You just have to kind of figure out which ones are doing that. If that's the way you're going and you want to go talk to a specific fund or investor that is into impact investing. Franchise models. Yeah, I mean, that's another way of structuring your business. That's totally outside of this presentation. The whole franchise method is one that's regulated. You need someone that really understands franchise law to help you if you want to set up a franchise. And then you're going to also want to make sure you're talking to the right investors, because there are investors that understand that model, that will invest in that model, and there are other investors that don't and won't. So you just want to make sure, again, going back to one of the earlier comments, is talk to the right investors. So do your research, understand who your investor is, and if it's the franchise model you're looking for, find someone that will invest in that. And I'm not sure what you mean by purchase LOIs. So happy to answer that if you want to email me some more specific info on that. Next question is, do C-note convertible note investors need to be accredited? Is C-note a security? Yes, and that's a good point. So anytime you're issuing securities, and securities is sort of a broad term, it can include a promissory note, a convertible note. It includes safes, warrants, obviously stock, options. All of those are considered securities, or and you need to make sure that as a security you're complying with the securities laws. So that's where you really need to get a good lawyer who understands this type of work, who does work with this, because the securities component is an important one. There are certain filings that need to be made. There's certain disclosures that need to be made, certain information you need to be gathering. And one of those is making sure that you do get information to confirm that the investors you're going out to talk to and get money from are accredited. You can get money from unaccredited, but that's a totally different topic of discussion. It's a lot more involved. You've got to jump through a lot more hoops. If you can make sure that you're only selling securities to accredited investors, it's an easier process. You still have to fulfill and follow the securities guidelines and requirements. But again, that's where oftentimes the lawyers will come in, because they understand those regulations, they understand what's needed. They'll make sure you get the right documentation, get the right filings done to make sure that you have the exemption you need. Very quickly in the US anyway, the only two ways to sell securities are either you register your securities, so think of going public, very expensive, very time consuming. Startups obviously cannot do that. Or you get an exemption from the registration requirements. And that's the path that startups go down, is getting an exemption from having to register the securities. There's a lot of exemptions. There are exemptions both at the federal level and the state level. So it can sometimes be a little bit of a spider's web, making sure you navigate and get the right exemptions. So using and working with your lawyers on that is going to be critical. Next question. Do startups need a securities lawyer? I think I just kind of answered that one. And it should be, if you're working with a lawyer, make sure it's a lawyer that does work with startups. If they have worked with startups and they understand the startup world, they will understand the securities that are involved with startups. So typically it's going to be a corporate attorney, and corporate attorneys typically also are very familiar with the securities laws as they apply to the types of companies that they're working with. So yes, I certainly recommend working with one. Can you incorporate in Delaware even if you're not a U.S. citizen or resident? Yes, you don't have to be a U.S. citizen, don't have to be a resident of the U.S. to form a company in the U.S. or in Delaware. Where that becomes important is if you're going to be involved in operating or managing, running the entity in the US, then you need to make sure you've consulted with an immigration attorney, because if you're doing everything overseas, that's fine. But if you're ever going to come to the US and engage in any sort of activity that would be considered working for the company or engaged in running the company, then at that point you need to make sure that you're getting good immigration advice, because at some point you're going to need to get authorization to actually work in the US, to come to and work in the US, live in the US. And that's where an immigration attorney would be very helpful to make sure that you've got the qualifications and you get the right documentation in order to do that. Otherwise, if you're staying abroad, you can hire people locally. It's a little bit more challenging because if you don't have someone that either yourself as the founder or close advisor on the ground seeing the day-to-day, it's tough to kind of manage from afar. But an immigration attorney is going to be very helpful. We have an immigration practice at our firm, and so we liaise and work with our immigration attorneys on a lot of the startup stuff where they're coming in or setting up a presence from outside the U.S. Question about services and the costs. I'm happy to answer those questions offline. What is the cost to create a private limited? Well, private limited is the title usually held for foreign companies in different jurisdictions. We don't use that title here in the U.S. In the U.S., reach out to me. I'd be happy to kind of talk about, what the typical costs might be. What happens to, I'm just checking the time, so we've got about 8 minutes left. What happens to ownership percentage if one of the co-founders passes away and the agreement was done through a SAFE? Well, I'm not quite sure I understand the question. So one event is a co-founder passes away, and then looks like there was also the company issued a SAFE. So if you're a co-founder, that means you formed the company, and so that means typically you've actually got some ownership, you've got shares in the company. So let me take that as a separate standalone question. If you've got two co-founders and one of them passes away, the shares that co-founder that passed away own, you're going to have to understand what happens to those shares, and it's going to depend. Did they have an estate plan in place? Are they in a particular state that's community property where maybe their spouse might have rights to those shares? Is there estate planning documentation that was prepared that allows for the transfer from the co-founder to his or her spouse or to children? Or if there's nothing in place, then you're going to have to look to the state's laws of intestacy to see what happens to assets that are owned by someone that passes away. Every state has, in the U.S., has a manner of deciding and then distributing assets when someone passes away. So it goes to typically your heirs, but that may be a lengthy process. And that raises a really good point. I touched on very briefly, but I didn't go into detail on this, as I did talk about shareholders agreements. So sometimes the shareholders agreements can be between co-founders, and one of the areas that they can cover is what happens if there is some sort of event like a disability, retirement, or death, or divorce. Any or all of those can create havoc for the company, because it can put the company in a situation where now the company doesn't know how to act because one of the co-founders has undergone an event which creates some confusion as to the ownership of their shares in the company. So a shareholders agreement can cover all those scenarios and have a process that plays out to make it a little bit more streamlined and transparent with more clarity on what can happen. Okay, so another question, can you explain more on the tax process of an LLC and a corp? So I'll do a very sort of high level description here of these two different entities. So corporation we talked about, there's two different types of corporations. There's a C corporation, which is if you just form a corporation and you don't do anything else, it's going to be automatically a C corporation. The C refers to chapter in the IRS code that references how they're taxed, and typically it's double taxation. So the corporation pays a corporate tax rate, and then once you take any proceeds from the corporation and you distribute them down to the shareholders, you'll pay another tax at the shareholder level. So that's double taxation. It's not great. You can manage for it if you have a good accounting firm and they make sure you're taking advantage of deductions and credits and things like that, expensing things. But essentially, that's the double taxation of a C corporation. So you can also elect to be treated as an S corporation by filing an S corporation election with the Internal Revenue Code, Internal Revenue Service, that then treats the corporation as a pass-through, like an LLC, which I'll talk about in a moment, that essentially eliminates the double taxation. So the money's come into the corporation at the corporate level, but the corporation doesn't pay any tax once the distributions are made, or they pass through to the individual or the shareholders, and the shareholders pay tax on their allocated distribution of profits, so, or income. So it saves you that one level of taxation, but it's limited. You can only have a certain number of shareholders. Shareholders have to be typically individuals. In some instances, you can have a estate planning trust, but there's all sorts of limitations of who can be an owner of an S corp. Investors don't like them because it's a pass-through, and they don't want that pass-through treatment. That's similar to an LLC. An LLC is taxed like a partnership, which essentially is a pass-through. So same scenario. The income comes into the LLC. LLC pays no tax. It then is passed through to the individual members of the LLC, the owners, and they pick that up on their own returns, and they pay whatever their appropriate taxes on their income. Again, investors typically don't like the LLC form for the reasons I explained earlier. So, but that's sort of the main high-level difference between the two. Okay, it looks like we got a few more minutes, and I'm probably not going to get through all these questions, but I will do my best. What process do you advise to engage with a VC angel investor, and should the founders be assisted with a lawyer at all stages? Yes, I would say definitely get a lawyer to help you. Here's the thing. When you're talking to an investor, if they're a sophisticated investor that's been investing for a while, they are going to know the term sheet inside and out. They will know it much better than you will ever know it. They will know all the terms. They will know all the negotiated points. They're coming to that meeting with a tremendous amount of experience and savviness and knowledge about how to negotiate the best deal for them. If you haven't done the same, you're at a tremendous disadvantage. If you don't understand the terms, if you don't understand how certain things are going to work, if you don't understand how it's going to play out, then you may agree to something not understanding what's going to happen, and then later on see the impact of it because you ended up giving away a lot more than you should have, didn't negotiate a certain provision that would have helped you or protected you more. So bringing a lawyer that's knowledgeable and experienced involved early on in the process is going to be tremendously helpful, because now you're leveling the odds, you're leveling the playing field, if you will. So as those terms, which sometimes can be complicated, are being negotiated and discussed, you've got your lawyer there to go to bat for you and make sure that you negotiate the best deal you can get. Another question is, do we need a CFO at the start? No, again, it depends on what the needs of the company are. And, you know, if you get to the point where there's just a lot going on, you've either got revenue coming in or you've got enough investments coming in and expenses, you need someone that understands how to run things financially, then yes, I would certainly encourage you to get a CFO. You don't have to necessarily go and hire a third party. You know, there are also, I mean, like a full-time person, there are companies that can provide that. There are fractional CFOs. So there are companies that you can go out and say, look, I need a CFO, but I need someone 10 hours a week, 20 hours a month, whatever the case may be. And then you can have them come in on that sort of a fractional basis to provide you with support that you may need. On safes, does the investor need to be accredited? I think we answered that. Yes, any security, if you're going and selling a security to an investor, then you want to make sure that they're accredited. You can do it if they're not unaccredited, but I would advise against that, because it's a whole different ballgame if they're unaccredited with the things you have to do to make sure you're compliant with securities laws. Okay. Let's see. Question, do I hold similar webinars on IP licensing, foundational basics? I myself don't, because I'm not an IP attorney. However, I have a number of colleagues at our firm, and this actually is a good segue in the few seconds I have left to say, which I didn't early on, is Foley and Lardner, the firm I'm with, is a full service global firm. We do full service for startups all the way through emerging, more mature companies. And so it's not only the stuff that I do as a corporate attorney, but it's everything, from A to Z, or as we like to say, garage to global. It's employment, tax, IP, litigation, trademarks, patents, you name it. There's likelihood that we do it. If you're a foreign company looking to set up operations or a presence in the US, we do a lot of cross-border work. We do a lot of work with people coming in, companies coming into the US. So all of the issues that come up, import, export controls, any of the issues with CFIUS that may come up, or other regulatory issues that need to be discussed and you need advice on, we can handle all of that. And then we've got a number of different practice areas. So energy, life sciences, healthcare, tech. And in those areas, we have specialists that have very deep knowledge in that particular industry or sector, so that they've got that understanding of what the issues are, especially on the regulatory or compliance side of things. Okay, so great. I think I walked through almost all the questions. Again, if there are any more that I missed, or if you didn't get a chance to ask, feel free to reach out. I'm available. My information's on the screen there. It's been delightful to present to you. Hopefully I gave you some information to think about, some information that you can walk away that will hopefully help you in your venture, whether it's setting up your company or if you're a little bit further along the adventure. And if there's anything I can ever do, don't hesitate to reach out. But thank you again for your time. Really appreciate everyone attending, and good luck with your ventures.